Hello, my name is Fleur Kingham. I'm Chair of the Queensland Law Reform Commission, and I'm here with Rachna Nagesh, a Senior Legal Officer at the Commission, and we're going to share with you an overview of what we've heard from different people and communities about our Criminal Defences Review. Our review is considering the circumstances in which violence, largely violence that leads to death, can be excused by law or treated as less culpable because of the circumstances in which it occurred. In February, we released a consultation paper that put forward 7 proposals and asked for your views. And we have just published our 4th background paper, which summarises what you have told us.
We are grateful to everyone who has shared their views with us. We heard from a broad range of people and organisations, including people from diverse and disadvantaged communities. We spoke to 492 people throughout metropolitan, rural and regional communities. We interviewed 32 legal professionals, including Supreme and District Court judges, magistrates and criminal law practitioners. We also spoke with 9 youth advocates and young people in a focus group, and we received 44 written submissions.
Key themes are apparent to us from your feedback. Many of you support changing the law of self-defence to make it clear, simple and fair. You told us that the test should include objective and subjective elements, with some supporting greater objectivity. You have told us that it should cover circumstances where domestic and family violence victim survivors use defensive force, and that it should recognise cumulative harm and social entrapment.
We heard that most of you think judges should have discretion when sentencing for murder, so that sentencing can reflect contextual factors relevant to culpability, including the gravity of the crime, the offender's background, the circumstances and relationship with the victim, and their response to the offence. We heard a different view from homicide victims' families, who are generally not supportive of judicial discretion.
You told us that partial defences that reduce murder to manslaughter are critical given Queensland's mandatory penalty for murder and minimum non-parole periods. They are an important safeguard for domestic and family violence victim survivors. You told us that any reforms to partial defences or the introduction of new partial defences must be considered within that broader reform context.
Many of you consider provocation as a partial defence to murder and as a defence to assault inconsistent with contemporary attitudes and beliefs, and not working fairly in the domestic and family violence context, though it can be relevant for violent responses to racial harassment and vilification.
We heard that the defence of domestic discipline should be limited or repealed, as it doesn't reflect children's rights and contemporary understanding of child development. And we know that childhood experiences of violence can lead to adult violence. Some of you noted concerns about the implications of repeal or reform, particularly for teachers and vulnerable communities.
Most of you said that we need practice and procedure reforms to improve access to defences and access to justice, particularly for domestic and family violence victim survivors and Aboriginal peoples and Torres Strait Islander peoples. We also heard about broader issues with the criminal justice system that might be outside the scope of our review, but are still relevant to understanding how the defences work in practice. Key issues are the overrepresentation of Aboriginal people and Torres Strait Islander people, access to justice issues, and delay in the criminal justice system.
We have only had a chance to briefly touch on the extensive feedback we received, and we invite you to have a look at our paper for more details, as well as at the written submissions which are all published on our website. Our next steps are to continue to explore the issues you have raised with us, to develop our final recommendations, which we will provide to the government by the 1st of December this year. I want to thank you for taking the time to share your views with us. Consultation is at the heart of our work, and we value the opportunity to have ongoing, meaningful engagement with you.